Good morning, everybody, and welcome to Law and Crime. I'm Jesse Weber, joined here on set with trial attorney Brad Micklin. We're going to break down the biggest live trials and legal stories in the news for you, so let's get started right now. Okay, so I know that can get kind of confusing about with all the different Jane Does and what counts are still on the table, so I want to put it up right now about what we have to consider in this new trial that is going to be starting today based upon where the jury went and where this new jury will go. So if we have that graphic, I'd like to put it up right now. So what we're talking about right now is Jane Doe's 1. We're talking about Jane Doe 2, we're talking about Jane Doe 4, and what happened is Jane Doe 5, which we thought was going to be part of this trial, we learned last week, will not. Those charges, counts 11 and 12, will not be part of this trial. They may be retried at a separate time. Brad, I want to come to you now. Based upon this, what does the prosecution need to do in a new case in order to secure these convictions, especially for the rape and sodomy charges?
I think they need to work on the credibility issue. There was a lot of credibility issues with Jane Doe 1 and 5, I think it was. And when you have a second chance at a prosecution like this, you really need to make sure that whatever held you back from the first one, you clean up now.
And maybe that's what will happen. Look, I'm also here with criminal defense attorney Joseph Tully. Joseph, let me ask you this question, difficult question, because it's all based upon the testimony of the Jane Does. So the Jane Does that theoretically you do not need for this case, so Jane Doe number 5 or Jane Doe number 3, do you still, as the prosecution, would you still bring them in, have them testify, because maybe their accounts will help bolster the credibility of the other Jane Does? Because in the first trial, the jury was actually instructed, I believe during closing arguments, that if you believe Jane Doe number 3 or 2 or 4, you can use that in your analysis of Jane Doe number 1. Would you bring those Jane Does back on, even though the jury would no longer have to really consider those counts?
Sure. Generally speaking, prosecutors like to pile on as much evidence as possible, or as much bad stuff as possible that they can. Juries are human beings, so the more people you have accusing somebody, the more the defendant is going, or the more the jury is not going to like that person. So in California, we have something called 1109 evidence, and basically in a domestic violence case, anything bad that he has done against any female ever can come into court and be used against him, which is unlike any other crime. Generally speaking, if you've robbed 10 banks before and there's another bank that's robbed, they can't bring in those 10 other banks unless there's other certain reasons. Except in the case of domestic violence, anything that he's ever done can be used against him, and prosecutors don't shy away from using it.
And we know that the defense actually tried to get a new trial saying it was improper for the same jury to hear the indecent exposure charges as well as the rape charges. The judge denied that. We are moving on to this new trial. And when we talk about a jury pool here, I guess the question is, the defense has been raising some objections to the jury that's being selected. There were issues about what were they being informed about this trial too early on in the process. They found out his name too early on in the process, but also that there's not a good representation of African Americans on the jury. I don't know if you had a chance to see any of that and what you think about this new jury pool.
Well, there's not really much you can do about that. I mean, the jury's picked from a pool of residents, and the research has suggested that there's not a great deal of African Americans inside of this area where he resides. But you also, when you do have jurors, you can't dismiss them because you don't want the race on, and that was what the issue was, that they thought they were trying to exclude them intentionally, and that's unconstitutional.
Look, the defense needs to do whatever they can try to do in this case. And you know, Joseph, I have a question for you. Would you say that this was more of a win for the defense in the last trial? Look, a hung jury, not necessarily a win. They want not guilty. However, it's not a loss. And so if you're the defense, do you move forward with the same strategy that you did in the first trial? Because yeah, you got a hung jury. However, you did get some guilty counts there. And also, when you look at the split, most of the jurors were favoring guilt on those charges. So do you switch up your strategy if you're the defense?
I do. When I go to trial, and if there's a hung jury the first time and we go back, I always switch up my defense a little bit. I mean, in some ways you beef up your investigation and your strategy based on the feedback that you hear from jurors. I mean, you want to always do better, so why not change it up?
And that's a good point, but what would you do, Brad? I mean, again, how much do you change cross-examining these Jane Does? I thought they did a pretty effective job at trying to show that there were credibility issues, but what did they need to do more?
It's difficult to say until you know exactly which Jane Does are being called. Everybody makes mistakes or second guesses themselves at trial. So here you had a lot of issues and a lot of charges and a lot of people. Now, for instance, Jane Doe number 1 had probably the most credibility issues. If she's going to testify, you can use those again and without having to clean much up. But the other ones where there were more serious charges found, you really need to figure out what you did wrong the first time.
Yeah, no, absolutely. But right now is going to be opening statements today. And Joseph, what do you need to do for an effective opening statement as the defense?
There's different strategies. To me, I think the best strategy is to throw out all your cards on the table, be 100% upfront about the strengths of your case as well as the weaknesses of your case, and give the jury exactly what you intend to present. You don't hold anything back in opening. As I've sort of progressed in my career and developed my trial skills, that's what's worked best.
Unfortunately, we keep hearing that sometimes a jury makes their decision, even though they shouldn't, they make their decisions after opening statements. They should really consider all the evidence, but that just shows you how important opening statements are, the first thing they hear about this trial. Now, we're not quite there yet. We're going to keep recapping the first trial, and when we come back, we're going to start with the testimony of one of the most controversial witnesses, Jane Doe number 1.